expert witness paramount duty, very high duty, is to the court and not to the person from whom the expert has received instructions or by whom he's paid. An expert witness is not an advocate for the party. He cannot submit arguments. He's only forming the opinion based on the facts or data available. Declaration of duty to the court, that's the verification or like a statement of truth. Report not admissible unless the report contains a declaration by the expert witness that he has read this code of conduct and agrees to be bound by it, understand his duty to the court, and complied with and will continue to comply with that duty, what was on your PowerPoint slides, in other words. This is too technical, don't worry about it. Expert report to be verified by statement of truth. The expert report itself must contain the expert's qualifications as an expert, facts, matters, and assumptions on which the opinion in the report are formed, reasons for each opinion, state if any particular question or issue is outside his field of expertise, any other literature or opinion in documentary form. Okay, any tests or examinations that he has conducted. Okay, so if there are any limitations, I won't read it out. If the expert believes there are any limitations in his report due to factual circumstances, due to, let's say it has been raining in the last few days, so you can't isolate the source of the water leakage, things like that, limitations he has to state in his report. So basically, that's the kind of things that is in the code of conduct. Okay, code of conduct of expert witnesses. Now we turn a different page to the topic of discovery. Discovery is very time costly, but is necessary. So what is discovery? Discovery is the mutual disclosure of all evidence in support of the case, in support of or in adverse to the case. Okay, notice the word mutual. So I disclose to you and you disclose to me what you have. I disclose to you what I have, you disclose to me what you have. Pleadings in an action is deemed to be closed. Remember, we went through this already. If there's a reply at the expiration of 14 days after service of the reply. If no reply, but a defense to counterclaim. Remember, a defense to counterclaim is at the same document with a reply, if there's one, right? So essentially, this 2 point means the same thing. Normally, it's a reply and defense to counterclaim, but it can be only one. That's all it's saying. Okay, 14 days after either of them. If there's no reply nor defense to counterclaim, then at the expiration of 28 days after service of the defense. So then, that's the close of pleadings. And discovery occurs or takes place after close of pleadings. Effect of discovery is to allow the parties to assess the strengths and weaknesses of its cases. Encourages settlement, and again, no surprise, no ambush. Everything out in the open. Failure to comply with the requirements of discovery may lead to the court imposing an unless order, which means that an action can be struck out or dismissed or stayed until the order is complied with. Unless order, right? Basically, unless the parties take discovery, mutual discovery, or a list of documents within 14 days or within 28 days of this order, the action be stayed until whenever, like that. So that's how an unless order is phrased. So we say, yes, mutual disclosure, I disclose to you my documents, you disclose to me what you've got. So is it everything and anything? Right? You must have have a limit, right? You can't throw everything in. So what to throw in? We want enough, right? So that we have everything that is relevant to the case, but we don't want the extra things that are irrelevant. So scope of discovery would include any relevant documents, but how do we test what is relevant? The test of relevance is in the famous case of Compagnie Financière du Pacifique and Peruvian Guano. This is commonly known as the Peruvian Guano test for the test of relevance, okay, of what to include in documents. So the Peruvian Guano test, it would include any documents that could be used to prove or disprove any issue in the action, or contains information that may directly or indirectly enable a party either to advance his own case or to damage the case of the other party, of his adversary. So in other words, documents or evidence that can support one of the parties' case. Now the word document includes papers, recordings, information stored on computers, disks, photographs, emails, contracts, receipts, board minutes, correspondence, accident reports, anything that can be put into permanent form, right? Pretty much. So remember, the Peruvian Guano test is important. Now, on the other hand, we don't want too much irrelevant rubbish. So on the previous slides, we say we need everything that may potentially be relevant. We want everything relevant. We don't want to miss anything. On the next slide, we are saying, but we don't want rubbish. Okay, discovery only if necessary. If a party make an order for discovery before the court will not grant the application unless it's satisfied that discovery is necessary. Okay? The court will not grant the order if discovery is not necessary or not yet necessary. Right? Not necessary and not necessary at that stage. May dismiss or adjourn the application if it is not necessary yet, and shall in any case refuse to make such an order if and so far as it is of the opinion that discovery is not necessary either for disposing fairly of the cause or matter or for saving costs. Okay, so first of all, it says, okay, we won't grant any order of discovery applied by any party if it's not necessary or not yet necessary. And then you ask, so what do you mean by necessary? So the last bit of it defines what's necessary, right? Necessary as in it would help to dispose fairly of the cause or matter, so to resolve the dispute, or for saving cost. Now the very first thing is supposed to happen after close of pleadings when we move on to discovery is automatic discovery. So what happens? Three things, right? Under automatic discovery, it is what it says, automatic. So after close of pleadings, what the parties should do is to have automatic and mutual disclosure of the list of documents. Documents that are in each party's respectively possession, custody, or power, pursuant to Order 24, Rule 5. The whole of Order 24 is on or about discovery. Okay, so what one here, it's being very brutal. What is, I'm forgetting to make it slide. So what happens here is only a list. Okay, notice item number 1 is only a list. and that list is called list of documents. Okay, it would say, let's actually have a look at it. There's a sample list of documents on page 124 of your manual, but otherwise, I've also got a real one for you. Okay, so title, action, numbers, parties, etc. So this is a plaintiff's list of documents. Okay, because I assume you can have your leisure time to look at the one in your manual. So plaintiff's list of documents. The following is a list of the documents relating to the matters in question in this litigation, which are, can you see it? Which are or have been in the possession, custody, or power of the plaintiff, and which is served in compliance with the order of whichever master on whichever date. Right? It should actually happen automatically, but obviously the parties in this action have not been so good. They've been a bit naughty, so it's taken an order of a master to make them do it. Now, it states, the plaintiff has in her possession, custody, or power the documents relating to the matters in question in its action enumerated in Schedule 1 hereto. Now, under Schedule 1, this is pretty standardized, okay? They wouldn't change what the nature of the documents in each. So, Schedule 1 is actually broken further down into two parts. Part 2 are the ones that the party is claiming privilege, meaning you can't see it. Okay, so yes, I said everything in, again, Schedule 1 and Schedule 2. Schedule 1 is further broken down into two parts, Part 1 and Part 2. Schedule 1, Part 1, I agree, I can show it to you, and I can give you copies. Part 2 of Schedule 1, no, I admit I have those, but I'm not going to give it to you because they are privileged, meaning it is under protection from disclosure. As to Schedule 2, see, the plaintiff objects to produce the documents enumerated in Part 2 of the said Schedule 1, on the ground that they are, or by their nature, privileged from production, such as, well, without prejudice communications, such as solicitor-client communications, and so on. Number 3 is saying the documents listed under Schedule 2, those documents, I used to have them, but I don't have them anymore. Okay. See, the plaintiff has had, but has not now, so no longer. In her possession, custody, or power, the documents relating to the matters in question in this action in Schedule 2. Right? Okay, so this is a real case. So Part 1, can you see Schedule 1, Part 1, and Schedule 1, Part 2? Right, so Schedule 1 are the items that I say, everything in Schedule 1 I have now, even until now, okay, in my possession, custody, and power. And I don't object to showing you the ones in Part 1, but Part 2, the ones in Part 2, I'm not going to show you. They are privileged. How does it phrase it? Correspondence and communication between the plaintiff and his solicitors in respect of this action and all other correspondence and documents prepared and obtained for the purpose of this action. So it's a very general description. Okay, this is a pretty standard. Okay, what is in Part 2, Schedule 2? The original pleadings and other documents which have been filed in court in this action, and the originals of documents in Part 1, which have been sent to the respective addresses. So the originals of certain documents, I don't have the originals anymore, is what they're saying. Okay, so that's a list of documents. Okay, or else you can look at the one in your manual. That's also okay. So we were looking at item number 1 here out of the 3 stages. So you've just seen a list of documents. After that, after the mutual exchange of that list of documents, you give photocopies of these documents. Which ones? Schedule 1, Part 1. Because Schedule 1, Part 2, I'm saying you are not entitled to it, so I'm not going to give it to you. And as to Schedule 2, I don't have those anymore, so I can't give it to you. Okay? Inspection of original documents. So what happens? I shouldn't have closed it. I missed showing you one sentence. So the list of documents would have one, where is it? Here, notice to inspect. At the end of that document, it would have a statement saying, take notice that you can come and inspect the originals, because I'm only giving photocopies, remember, to the other parties, because I'm, of course, have to keep the originals. But if you want to come and see the originals, yes, you can come to the solicitor's office at whichever address and at what time, okay, by prior appointment. So I'm offering, or both parties have to offer the occasion or time when the other side can come and inspect the originals. Okay, that's the notice to inspect. That's the last bit here. Inspection of original documents. Okay, that's what I just said. So pretty much Schedule 1. Schedule 1 is everything that is currently within my possession, custody, and power. Out of the whole of Schedule 1, what I have, remember Schedule 1 is what I have. Schedule 2 is I used to have, but I don't have anymore. Okay, Schedule 1, Part 1, yes, you can see them and I'll give you photocopies and you can come and inspect the originals. I'll give you the time stated, okay, within the time stated. Schedule 1, Part 2, privileged documents. Privileged. So not entitled to disclosure. Okay, the other side not entitled to see. Okay, which the party does not object. Part 1 does not object to production. Production in this case just means give photocopies. Okay, that's all it means. This word production. Okay, so Schedule 1, Part 1. I have it in my the party has it in its possession, custody, and power, and the party does not object to giving photocopies of it or let them have inspection. Schedule 1, Part 2. Yes, in the party's possession, custody, and power, but the party does object to the production. Schedule 2, documents which have been, but at the time of service of the list of documents are no longer in the possession, custody, or power of the party. Then you have the notice of inspect, which you looked at. State when and where the documents can be inspected, as in the originals. Okay, now discovery has many, can have many variations. The ones we've looked at just now is only the automatic discovery. Okay, every case has to have automatic discovery, whereas the following is not mandatory. Now you can have application for further and better discovery under Order 24 again, but this time Rule 3. If one of the parties has failed to serve a list of documents, or the list served is inadequate, in that it fails to disclose relevant documents, the other side can apply to the court for a further and better list. In other words, give me a better list. This one, I know there's stuff that you haven't put on it. Okay, don't hide. Guess what? Application by summons. Okay, application by summons inter partes. No need to prove the documents sought exist. The court will grant an order for discovery if there's no list of documents served or a reasonable suspicion that the documents sought exist. Oops, did I miss? Specific discovery. If a party fails, this is even more specific than the further and better discovery. If one side, or if a litigant, fails to disclose certain relevant documents contained in its list of documents, the other side can make application for specific discovery. Application by summons and affirmation to show that the documents sought exist or existed, that they are or have been in the other party's possession, custody, and power, and that they are relevant, okay, as in relevant to the proceedings. Now, privilege. Privilege is the reason why a party can object to disclose certain documents. Right? It's immunity or protection against inspection or discovery. No privilege is automatic. The party trying to claim privilege, as in the party who doesn't want to disclose certain documents, etc., must show and assert the privilege and state the basis. A claim of privilege must be made out in the list of documents with a sufficient statement of the grounds of the privilege. If you don't want to show it, tell us why or on what basis you're claiming privilege. Legal professional privilege is one type. Basically, what it is solicitor-client communications, okay, for which the main purpose is to seek legal advice, or those communications are made in contemplation of litigation. Under this basis, you can claim LPP, okay, legal professional privilege. If you go on to further studies, you will look into it in further depth, okay, because even the term client has been interpreted quite widely. For example, it may include potential clients, right, even before they engage you, okay, so, or subsidiaries of clients, etc. So it's been given quite a wide interpretation. Procedure to claim legal professional privilege under CITIC Pacific Limited and Secretary for Justice. Number 2. First of all, identify the materials where LPP is claimed. So what documents are you trying to assert privilege? Specify with reference to the materials identified whether the LPP, legal professional privilege, claimed is legal advice privilege or litigation privilege. The distinction is here, okay, the two parts. And support the privilege claims by statement or affirmation outlining the basis and factual context of the privilege that is claimed with reference to each of the identified materials. In other words, if the materials or documents you're trying to protect from disclosure, if they are of certain different categories, you've got to state each category and then state the basis. Is it on the basis of communication in contemplation of litigation or legal advice sought, etc.? Right? You've got to do it in categories or by item. Without prejudice communications. Have I explained to this class without prejudice save as to cause? Yes? Right? Everybody understand? Okay, sure. Okay, so without prejudice communications are any communication made between the parties in a genuine attempt to settle the dispute. Now, of course, if the case continues, that means that, well, they tried, but they didn't settle, right? But even if the parties did not ended up being successful in the negotiations, those communication made during those attempts are protected and privileged. Okay, and that's why we call them without prejudice, right? Without prejudice, safe as to cause. Everybody still remember that, right? And normally in a letter, you see this, those WP letters, you see it sort of here, right? Without prejudice, safe as to cause, and then they'll have whatever, whatever, whatever. Okay. Remember, safe means except for cause implications. Without prejudice, as in do not prejudice, they should make no prejudice to at trial. The fact that those negotiations actually took place or offers have been made should not prejudice the trial judge's impression of the case. That's why they are not reflected until after the main judgment. Only safe as to cause, only when we deal with cause would the parties reflect to the judge that yes, we've made attempts, and normally that is used to persuade the court to give certain cost orders. Okay, so it would have, those privileged communications would have a bearing on cost orders, but other than that, on the main case, it shouldn't have any effect. Privilege against self-incrimination. So that probably speaks for itself. It's communications that tend to incriminate or expose a party or his or her spouse to criminal sanctions. International Management Group overseas, and Lun Sheng Mei Serena, and another. Well, one very controversial topic nowadays concerning land is Ding Ok, right? Anyone heard of that, right? Ding Ok and Ding Quan, right? Thou Ding, right? About village houses by indigenous villagers, etc., and selling those rights and cooperating with developers, right? To Thou Ding, what we call. And it is still going to be decided. That's still currently going to be a court of appeal case, I think, later on. But basically, this can pose as a good example. Let's say somebody tried to do the Thou Ding, right? Three parties. Normally it has the Ding, it has the landowner, and it has the developer, right? Sometimes the developer is the landowner. Okay, but such an agreement is at the moment still considered illegal, right? As of now, the situation, the current law, it is supposed to be illegal because one of the main reasons is there's a statutory declaration that says that yes, I own the land, so I want to build the house now, etc., etc. Well, what if occasionally they come up now and then, if the parties got into a dispute and the land is now vested in the Ding, then you have a problem, right? The developer may want to get the land back. Well, how? Because to make those or disclose, you may disclose things that are self-incriminating, right? Because, to make that arrangement, did you make a statutory declaration? Right? And that's one situation where you can get stuck. Right? Here, we're talking about, I don't want to disclose to the other side. But this is, sometimes there's such controversial stuff that you don't want to disclose, and you say, yes, it's self-incriminating. I am objecting to disclose. Okay, that is only an example that I can think of. Public immunity privilege, what is also called public interest immunity. Okay, PII. Communications which, if produced, would be injurious to the public interest. In Sony Rai and Coroner, the issue was whether to allow disclosure of the general techniques and guidelines used by the police to control individuals and crowds. It was argued that such disclosure would enable potential wrongdoers to develop countermeasures to thwart police operations. So that was one example of PII. Okay, what is the main aim of discovery? What is the main aim of discovery? Is for mutual disclosure. Mutual disclosure of documents, which has a wide meaning, right? Remember, it includes anything from documents, letters, computer disks, recordings, audio recordings, etc. Question number two. Two important considerations for the court when ordering discovery. What is, again, can you remember what is being tested under the Peruvian guano test? Okay, it says here already anyway, right? Relevancy, okay, gives you the answer anyway. Peruvian guano test for the test of relevance. And Order 24, Rule 8, which says that the court will only order discovery where necessary. Discuss the relative importance of each consideration. Which one do you think is more important? Relevance or necessity, in other words? Guess what the question wants you to say? Both are important. Okay? Because it is, when you don't you hear time and time again about discretion or circumstances will be taken into account of? And it is true, right? In order for the court to make a reasonable and sensible decisions, most of the time the court does have to take into account of all factual circumstances, exercise their discretion, weigh and balance against factors. And this is just another balancing exercise, right? It's nothing is really absolute. So you think, was it James or Simon who thinks it's a necessity? Why do you think it's a necessity? Right? So even though it may be relevant, it may not be so important. Okay? So on the borderline is what you're saying. Okay, maybe. How about privilege? Why do you think privilege exists in relation to discovery? It's almost like a defense, isn't it? It's like a defense against discovery, right? A little bit like that, like a shield. Why do you think we have privilege? It's very open. It's a very open-ended question, right? Why do you think we have privilege? Or we can let people assert privilege? Well, let's look at it. Why do you think we have legal professional privilege? Why do you think we have LPP? What do you think if I am James' legal advisor or solicitor, what do you think if our communication is not privileged? What would happen? He can't trust me, right? He can't trust me because his communication to me can be out in the open, right? He has to be very careful about what he tells me. It can relate to information as well as tactics, right? Okay, and weaknesses of our case. So that would be the reason. Okay, we cannot have what we say fearless advocacy. WP communications, I think by now you know why they should not be disclosed, right? Why should they not be disclosed? Because it would cause prejudice. And why is it not good? Okay, if you've made the offer, you've made the offer. Why can't you let anybody know? Yes, prejudice. And on the other side, flipping the coin, if we have to be careful, okay, if I made an offer as a defendant, I made an offer to Simon, and it can be out in the open, and Simon can say during the trial, see, Vivian must have been in the wrong. She knew she was in the wrong. That's why she made me that offer, even before the trial started. So that would make a very bad impression of me at trial, right? And then what? Okay, first of all, that would be injustice, unfair. Secondly, because there can be many reasons why I want to settle, right? For all those reasons, too timely, costly, etc., and publicity. I may not be really in the wrong, right? But I just want to end the whole mess. Okay, that's why I offer. But if that's going to be used against me at trial, I don't want to do it. I remember under CJR, one of the underlying objectives is to encourage settlement, encourage and facilitate settlement. That's why it cannot be reflected. Otherwise, nobody would want to settle. They'll be in too much fear that it will be used against them. Right? So we want to encourage settlement. That's why WP communications not disclosed. Well, privilege against self-incrimination, I think that's self-explanatory, right? Why it would be, because particularly in criminal law as well. Here we're in civil litigation, but in criminal law and cases, witnesses that are not the defendant, witnesses are also don't have to say tell things that may incriminate themselves. Okay. Oh, that's what we have tonight. Okay. Now I'll say a few words about the assignment. Oh, did someone just ran out? Okay, should I wait till 1, right? Okay, I'll wait. Nothing really magical. But anyway, any questions on tonight's material? Okay, nothing. Next time we'll be on our next lecture will be on topic 10 and 11, and our final one will be on 12. Okay, so next topic is sanction offers and sanction payments, and then active case management. It's all about those timetabling questionnaire, pre-trial reviews, and all that. That should be a breeze. Okay. No. Now you should have your assignment question already, correct? Now, 2 parts, they are of equal marks. Okay, I think I already stated 50%, right? Just there. Okay, so I don't think they're difficult, pretty plain and obvious. Okay, we're just talking about the assignment. Yes, 50%. Just, I don't think I can give you any advice. It's pretty easy question, I think. Please do me a favor and please use font 12 for my benefit, for the benefit of my eyes, and have some spacing, like at least 1.3, if not 1.5. 1.5, I'll love you even more. So yes, at least font 12, please. Okay. Anything else I can tell you about the assignment? They're of equal marks, I said already. So don't forget to cite authorities and rules. Nothing else really I can tell you. Right? It's pretty plain. It's a pretty plain question. Right? Unless you've been falling asleep from the beginning to end and don't replay the lectures. I think you'll all be fine. Okay, it's quite early tonight. Will you complain? I see vigorously shaking heads. More response than I've got from the whole night. Okay, if you have no questions, I'll probably stay around until 9:30 or so. If you have no questions, you're welcome to go. Okay. Okay, sure. Because I don't see the point to turn on the new topic. No. Should be fine. It's up to you whether you support your answers with cases from the course manual or outside. It's up to you. I just want, at least so long as the answer supported by authorities. Okay?